Civil liberties protect U.S. citizens against certain government actions. Meanwhile, civil rights refer to positive actions the government should take to create equal conditions for all Americans.
14th Amendment guarantees equal and due process of the law to all United States citizens.
Benjamin Gitlow, a member of the Socialist Party, printed 16,000 copies of a manifesto which encourages workers to overthrow the U.S. government.
Gitlow was convicted of violating New York state law that prohibited such advocacy.
Supreme Court ruled states were not completely free to limit forms of political expression. Courts claimed fundamental personal rights and liberties were protected by the 14th Amendment's Due Process Clause.
Selective incorporation, a judicial doctrine whereby most, but not all, protections found in the Bill of Rights are made applicable to the states via the 14th Amendment.
During the drafting of the Constitution, many Federalists wanted the Bill of Rights to guarantee the federal government could not limit certain rights. Questions today still come up with what degree to which federal laws can incorporate into state laws.
In Gitlow v. New York, Supreme Court ruled that state governments are not completely free to limit forms of political expressions. In Meir v. Minnesota, the Supreme Court incorporated the right to free press and disallowed the restraint of press prior to its publication. In DeJong v. Oregon, Supreme Court upheld the right to free assembly at the state level. In Engel v. Fidel, Supreme Court ruled that official prayer in public schools violates the Establishment Clause, indicating that students may not be forced to pray in school. McDonald v. Chicago, Supreme Court ruled that the Second Amendment to bear arms was fully applicable to the states because of the Due Process Clause.
The Third Amendment, the quartering of soldiers, has not been incorporated. The Fourth Amendment, the exclusionary rule, Mapp v. Ohio, the court ruled that any evidence obtained unconstitutionally is not presentable in a court of law.
Fifth Amendment, self-incrimination, Malloy v. Hogan. The Supreme Court ruled that the 14th Amendment protected the Fifth Amendment right to exemption from self-incrimination. Double jeopardy, Benton v. Maryland. Benton was tried twice for the same charges, and in the second trial was found guilty on both accounts instead of the single charge from the first trial. Just compensation, Chicago, Burlington, and Quincy Railroad Company versus the City of Chicago. Courts ruled that fair compensation must be given for any private property seized by the state.
Sixth Amendment, speedy trial, Klopfer v. North Carolina. The Supreme Court ruled that the 14th Amendment incorporated the Sixth Amendment right to speedy trial because the defendant was denied these rights when North Carolina left his trial open indefinitely. Trial by impartial jury. Duncan v. Louisiana. This was incorporated in a 7-2 vote that every defendant has the right to a trial by jury. Seventh Amendment, civil jury trial, not yet incorporated.
The Eighth Amendment, no cruel and unusual punishment, Robinson v. California. The court ruled that laws imprisoning people who had an addiction was cruel and unusual punishment, and that citizens have the right to be free from cruel and unusual punishments.
The Ninth Amendment, enumerating rights. In collaboration with other amendments, the Ninth Amendment has helped extend the rights of Americans, especially the right to privacy, in cases such as Griswold v. Connecticut, Roe v. Wade, and Lawrence v. Wade.
The Tenth Amendment. The Tenth Amendment, in use with other amendments, has been used to balance the power between state and federal governments, which is seen in cases like U.S. v. Morrison and National Federation of Independent Businesses versus Sebelis.
African Americans, Brown v. Board of Education, 1954, was 5 cases brought from different areas of the South and border states involving public school systems that separated schools for blacks and whites. The legal defense team represented by Brown argued that the separate but equal doctrine was unconstitutional and that the only way to obtain equality was to integrate the school system. The court ruled in favor, and through the next year and another case, Brown v. Board of Education II, the segregation was to be dismantled with all deliberate speed. Soon after Brown II, in December of 1955, Rosa Parks broke the law and refused to give up her seat to a white man on a public segregated bus. She was arrested, freed on bond, and gave the inspiration to start a movement that would change everything. The National Association for the Advancement of Colored People decided to challenge the constitutionality of segregation on buses and enlisted a young Reverend Martin Luther King to lead the coalition, which gave way to the protests, marches, and eventual court cases that ruled in favor of integration on the bus and the passing of the Civil Rights Act of 1964, which outlawed segregation altogether.
The Equal Pay Act of 1963 is a piece of legislation that requires employers to pay men and women equal pay for equal work. The Equal Rights Amendment is a proposed amendment that states equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. Title IX is a provision of the Education Amendments of 1972 that bars educational institutions that receive federal funds from discrimination against female students.
Affirmative action. Affirmative action is a set of policies designed to give special attention or compensatory treatment to members of a previously disadvantaged group. In 1978, Regents of the Universities of California versus Bakke ruled that the school could not take race into account as a factor in its future admissions decisions.
Hispanics. In Hernandez versus Texas, the Supreme Court struck down discrimination based on race and ethnicity and ruled that Mexican Americans had the right to a jury that included other Mexican Americans. Cesar Chavez organized migrant workers, united farm worker unions, and led them in a strike against produce growers in California. Hispanic key groups are the Mexican American Legal Defense and Educational Fund and the Puerto Rican Legal Defense and Educational Fund, which has been successful in expanding voting rights and electoral opportunities in Hispanic Americans under the Voting Rights of 1965 and the U.S. Constitution's Equal Protection Clause.
Asians and Pacific Island Americans. In 1882, Congress passed the Chinese Exclusion Act, which was the first act to restrict the immigration of Chinese. In 1886, Wick Wo versus Hopkins, discriminatory provisions in the California Constitution prevented Chinese people from practicing many professions. The courts ruled in favor of Wick Wo, citing that it violated the 14th Amendment because it targeted a single ethnic group. In 1922, Ozawa versus United States ruled the Asians and Pacific Island Americans were not white and therefore not entitled to full citizenship rights. In 1940, President Roosevelt issued an executive order putting 130,000 Japanese Americans, Italian Americans, German Americans, and some Jewish refugees into internment camps, the constitutionality of which was upheld by the Supreme Court ruling in Komatsu versus United States in 1944. In 1988, Congress passed the Civil Liberties Act, which apologized to the interned and their descendants and offered reparations to them and their families.
Gays and lesbians. In the late 1970s, gays and lesbian activists dedicated to ending legal restrictions on the civil rights of homosexuals founded Lobde Legal, the National Center for Lesbian Rights, and Gay Lesbian Advocates and Defenders, or GLAAD. In 1993, President Clinton tried to ban discrimination against homosexuals in the military, but out of that effort, he had to compromise and Don't Ask, Don't Tell was implemented. In 2003, Lawrence versus Texas, the Supreme Court ruled that banning sodomy was unconstitutional. Also in 2003, the Massachusetts Supreme Court ruled that denying the right to civil marriage of homosexuals was unconstitutional under the Commonwealth's Constitution. In 2004, initiatives prohibiting same-sex marriage were placed on 11 state ballots and passed.
Disabilities. In 1990, Congress passed the American with Disabilities Act. The statute defines a disabled person as someone with a physical or mental impairment that limits one or more life activities, or who has a record of such impairment, and thus extends the protection of the Civil Rights Act of 1964 to all citizens with physical or mental disabilities. 2004, Tennessee versus Lane, Supreme Court ruled 5-4 in favor that disabled persons could sue states that fail to make reasonable accommodations to ensure that courthouses are handicapped accessible.